and good evening, everyone, and welcome to the presentation tonight. We're going to talk about aging in place, and that covers a few different things. Estate planning, it covers considerations for paying for long-term care, planning for long-term care, and as Elizabeth said, I'm an estate planning and elder law attorney here in Connecticut. I work in the Madison office of our firm, which is Daly Perry Arnold and Kinnear, formerly Zapega Daly Pope and Perry, for anyone who's familiar with our firm. So I'll kick it off, kind of giving a little bit of background um, about Connecticut. So here in Connecticut, we have the second highest long-term care cost in the United States. The average cost is about 15,000 per month, 180,000 per year. A lot of that is driven by, this is an average, so a lot of it's driven by the Fairfield County. But regardless, it's a costly endeavor here. So what happens to people who run out of money? So if you need long-term care and you exhaust your resources paying for it, what happens? That's when Medicaid or Title 19 kicks in and pays for care. So who is paying for nursing home care in Connecticut? So this is the stats. Now these are a little old. They're 2022, but you see here that 17% of health or nursing home costs are covered by Medicare. And so as you probably know, Medicare covers, the first 100 days or a short period of time. They cover long-term care, but Medicare is a health insurance program. So it's not going to cover the costs of a nursing home or in-home um, assistance with activities of daily living, non-medical. So 10% people are paid privately, but you see that a majority of nursing home residents their attendance was being paid for by Medicaid. So what is Medicaid? It's a means tested program. So that means that its eligibility is based upon your assets, and it's funded by both the state and federal government. So it is going to kick in, as I mentioned, after someone exhausts their savings. Now, Medicaid, there is here in Connecticut and many other states, there is a home care program. It's a Medicaid waiver program. The waiver was enacted to allow Medicaid dollars to be used to pay for care inside the home. So in Connecticut, we have what's called the Connecticut Home Care Program for Elders. And that is a home care program. The Medicaid funded program will pay for care for assistance with activities of daily living for someone who wants to remain living in their home. And then, of course, Medicaid or Title 19 will also pay for nursing home care. So when we're talking about the steps that are needed so that someone is well positioned to age in place, step one, what we consider step one, is making sure that you have your estate plan in place. So you want a comprehensive plan that's addressing now and in the future. So what does that include? So it includes making sure that you have a power of attorney in place. Power of attorney is a document where you are naming someone or multiple people to help you handle your financial matters during your lifetime. So this is an important document in case you're incapable or in case you just need help. So you're not, by executing this document, you're not relinquishing your ability to manage your own affairs, but you're naming someone who has legal authority to help. If someone does not have a durable power of attorney in place and they are incapable of executing one, then their spouse or child or family member or friend would have to petition the probate court to have the person conserved and named, have at request that the court name a conservator who then would have the legal authority to act for that person. So that's not something that you want to have your spouse or family member have to go through. And you want to maintain control of who your power of attorney is. And by executing this document, you're doing that. You're saying who you want. You're not leaving it up to the court. So that's an important document. In 2016, Connecticut adopted the Uniform Power of Attorney Act, and the act, under that act, the power of attorneys documents have what are called hot powers. There are powers that you need to specifically initial in order to give them to your agents. Why is this important? A lot of these powers we actually end up using when we're doing planning for people, when we're trying to protect assets, we're trying to get people on Medicaid, and that typically involves transferring assets. If you need long-term care and you want to apply for Medicaid and you're not capable of transferring assets, you don't have you're not competent to do that, then we look to your agent, your power of attorney, to help execute those strategies, those asset protection strategies. And if your power of attorney does not give your agent those powers, then we're kind of stuck. There's no one who's going to be able to do it. So we often encourage people, even if you have a power of attorney already, that you want to make sure you review it and that it contains these powers that might be necessary should you wish to engage in long-term care planning or allow your agent to do it for you. The other document that is strongly recommended is a healthcare directive. And that is a document where you are naming someone to make healthcare decisions for you in the event that you can't make them for yourself. So this document, you're going to name a healthcare representative. You could also name a backup, so it could be multiple people. The document would include your end of life wishes. So if it is your wish to have a living will stating that if you are in a permanent vegetative state or in a coma, that you don't want to be kept alive through artificial means, that you can use this document to make those wishes known. And that would take that decision off of your healthcare representative. The last document is your last will and testament. So that by executing a last will and testament, you're maintaining control of who is going to manage your estate after you pass and where your assets are going to go. In the absence of a last will and testament, the laws of Connecticut would dictate all of that. And the laws say that it varies depending on your situation. If you're married, if you have children, if you're married, then your spouse gets the first 100,000 of your assets and one half of the remainder. Your children get the other half. So if you want to be able to, if you want to control where your assets go, it's important to take the time to execute these planning documents. Now, within the asset protection and long-term care planning context, we oftentimes, if we are working with a married couple and one of the spouses is ill or has a diagnosis, and it's likely that they're going to need care, that is a time when the healthy spouse is often looking at revising their last will and testament. So, and many times that means that you will not want to leave assets outright to your spouse who is ill, particularly in the situation if the person has dementia or Alzheimer's. If they're incapable of managing their assets. And in addition, as part of an asset protection strategy, we oftentimes will prepare the healthy spouse's will so that he or she leaves everything to spouse in a supplemental needs trust, which would allow them to qualify for Medicaid, and those assets would be there for their support to supplement what they're getting from Medicaid. So if someone is on Medicaid or needs Medicaid, healthy spouse dies and their will says everything goes to my spouse, that will leave them ineligible. And those assets will need to be used and spent down to pay for care. So that's a revision or something that we usually integrate into planning for long-term care planning for married couples. So number one, get your estate plan in order, get that all set in a time when you are able to think through everything. You're able to execute a plan. There's no question about your competency. So that's step one. Step two is this is thinking about protection of assets. So, and in many cases, for many people, one of their primary assets is their home. And there's kind of two aspects of asset protection. And the one that I'm talking about now is what we call proactive planning. So it's planning at a time when you are still relatively healthy. And the reason that that's important is because it involves transferring assets out of your name. In this case, we're going to talk about your home. And whenever you have a transfer of assets, if you need to apply for Medicaid, Medicaid has what's called a 5-year look back. The state is going to ask and confirm that you haven't gifted or transferred assets out of your name within the 5 years prior to applying for Medicaid. Because Medicaid, again, is a means-tested program, and in order to qualify, the applicant can only have $1,600 of assets in their name. And if you transfer an asset in the 5 years prior to applying, then the state will assess a penalty period. The state is going to say for every $15,526 you gave away, you will be assessed a penalty of 1 month. So the state will not pay for funding for 1 month. So if you look at in the context of a house, the house is worth $400,000 divided by $15,526. That's going to give you the number of months in the penalty period where the state is not going to pay for care, and you're going to have to come up with a different way to pay for it, unless you're able to undo the gift that you made. So when you apply for Medicaid, there's an application where the state does ask specifically if you've made any transfers, but also they are going to do a financial audit of all the accounts that you've opened or closed, so within the 5 years prior. And they're going to analyze the transactions to determine if indeed you've made any gifts or transfers of assets. So that's how the 5-year look back works. So provided that you are in a situation where you are planning proactively, so you're planning ahead, one of the ways that we protect assets, most commonly, again, a house, is by using a trust. And it's a special kind of a trust. It is not a revocable trust, which is more commonly used for probate avoidance. This is a trust that's irrevocable. A trust is a sort of an entity created by an agreement, a written agreement. And the agreement is between the grantor, the person trying to protect the house, and the trustee. When we're doing a Medicaid asset protection trust, or a Medicaid irrevocable trust, the grantor cannot be the trustee. The grantor has to give up some control of the assets that go into the trust. And the grantor also cannot be the beneficiary, because remember, you are saying to the state, this asset is no longer mine. This asset is now owned by a trust. The trust is controlled by the trustee, and the trustee is someone separate from the grantor. A lot of people say, can the trustee be my children? Yes, they can. It does not have to be an independent trustee who's made a trustee of the trust. So you have here the beneficiaries would commonly be whomever you'd want the asset to go ultimately. The trust document also explains it acts very much like a will or revocable trust in that it says when this trust terminates, and that trust would terminate either upon the death of if it's a married couple, upon the death of the second spouse, or you can give the trustee the discretion to terminate the trust, such as if you're in a nursing home and you're on Medicaid, and the house is sitting there empty, it may be your wish that your beneficiaries, your children, are able to, at that point, sell the house and distribute it. So the document can indicate when and how the trust terminates, and then it also says what happens to the assets in the trust at that point. It says that, it says who you want them to go to and whether you want them to go outright or in trust. So in that way, it operates just like a regular estate planning document. When you put a home, I'm going to advance this. So, like I said, the asset protection trust is irrevocable. You can maintain what's called a power of appointment so that you can change beneficiaries after the document's created. But the document itself cannot be revoked.
Want to
So
give up control.
I think someone's is not on mute, but the individual setting up the trust is not the trustee, gives up control. Now, although you cannot be your own trustee, you maintain a right to remove and replace the trustee. So if you've named someone and let's say you decide that you want to move, so you'd like to downsize and move to a different house, and you ask your trustee to please that you want to has the trust sell the house and purchase a new house, which it can do. It can purchase a new house for you. You maintain the right to live in it, and the 5-year clock doesn't start. But let's say the trustee is not cooperating. You can remove and replace that trustee. So there is some indirect control in that respect. So you create the trust, you transfer the assets, you transfer the house to the trust, and after 5 years, the house is not considered yours, and you're outside of that 5-year look back window. So what other assets can go into a trust? Well, sometimes people might also put in some liquid assets. They may put in an investment account. And that's kind of a tricky decision because again, you're not the beneficiary of the trust and you really kind of want to only part with that money if you're comfortable with that you have enough resources. So what can't go in? You can't put a retirement account in an irrevocable trust. For various reasons. You can't transfer ownership of a retirement account, and the RMDs would be paying out to you, so that won't work. While the house is in the trust, you maintain the right to live in it. You pay the carrying costs, so you continue to pay taxes, homeowners insurance, those types of things. So your life doesn't change in that way. So you decide to do this plan, and what happens if after 3 years you need care? You've run out of money, you need care, you need to apply for Medicaid. Your house is in an irrevocable trust. I've told you it's irrevocable. So what happens? In that case, there's a couple of options. If you haven't expended your money, all of your other resources, you may choose to pay privately through to year 5, because at that point you've hit year 5 and the house is protected. If you're in a situation where that's not possible, we can undo the trust and undo the gift. So we can distribute the house out to the beneficiaries or beneficiary, and the beneficiary can return the house to your name. And so now the house is back in your name. It's not protected, but you don't have a penalty period and as long as you're otherwise eligible, you can get on Medicaid. That's the worst case scenario. We can't undo the trust. Do we have any questions? Doesn't look like it. You can put them in the chat. I don't know or okay. Um, okay. I'll continue to monitor the chat if someone has any questions, and I'll stop and answer them. So let's see. A lot of times you've probably heard clients will ask, um, well, what about can I just put my house in my children's name? Doesn't that do the same thing? So, yes, it does. So, is the short answer. You can transfer your house to your children. After 5 years, it would be protected. Um, but there are certain risks associated with that, um, that's important to consider. So, and that is whenever you're transferring assets, legal title of assets to someone else, and those assets then belong to that person, you're subjecting those assets to anything that goes on in that person's or people's lives. So if you've transferred the asset to your child and the child passes away, well, that asset now is going to transfer to um, through that child's estate. If they have a will and they're married, it's probably going to go to their spouse. If they don't have a will, it's going to pass by the laws of intestacy. So now your house is now owned by someone who you don't want to own it. Um, what if you have a falling? I mean, the obvious one is what if you have a falling out with your child? So if you and your child no longer get along, you've transferred your house to them. Let's say you've kept a life estate, but you can't sell the house, without their consent. So you're kind of stuck. So you've really lost control in that situation. What if a child is sued? So you've transferred the title of the asset, the home into their name, and they're in a car accident and they get sued. The creditor is going to go after every asset that they can find in that person's name. I had a situation where someone put their mother on their house um, for for asset protection purposes. The mom ended up going into a nursing home. The mom never lived in the house. She went into a nursing home. She exhausted her assets. She had a bill outstanding, and the nursing home found that she was part owner of this house. So um, so they tried to pursue the house. Oh, I have to, I have automatic lights. And so that was an unintended consequence, um, of trying to protect a house. What if a child gets divorced? So now the potential is that this asset, your house, could potentially become a marital asset. So that's another issue. And the other thing to consider is, whenever you're transferring or gifting an asset to multiple people, things can go bad if they have a falling out or they're not getting along. So lots of risks to consider. I'm not saying that this is, it's bad in every situation, but it certainly does raise some concerns. Um, so why is using a trust better? Well, your assets are going to be owned by the trust, and they're going to be protected from not only your creditors, such as the state of Connecticut, but also the creditors of the beneficiaries. So the people who are ultimately going to get the house. Unlike if you transfer it to them, the house to them directly. Using a trust, you do maintain some control because, as I mentioned, you can remove and replace trustees, and you also control where that asset ultimately goes. So, again, you say that when you pass and the trust terminates, you want that asset to go to your children or your grandchildren or whomever you'd like. Okay, so This is something I hear often from clients, which is my house is already in a trust, so I'm all set. And again, there is the important distinction between a revocable trust and the irrevocable trust that I just explained to describe to you. Revocable trusts are estate planning tools. They're an alternative to a will, and they're commonly used to avoid probate. You're not giving up control. Uh, you're not giving up access to the assets. There's a lot of flexibility. You can revoke the trust, you can change it, you can take assets in and out of it. So from that perspective, it's your asset. And it is not protected. There is no asset protection. So just to kind of give you this overview, the revocable living trusts are used often to avoid probate, particularly if someone has out-of-state property. It can be helpful. They're private documents, unlike a estate that goes through probate. They can allow for incapacity planning. You can say, if I'm incapacitated, this is how I want the trust assets to be used, and here's how I don't want them to be used. And they're also good vehicles for tax planning. The irrevocable that we commonly, so there's many different types of irrevocable. Some is for estate tax planning, but the one that we're focused on for the purposes of this presentation which is asset protection, is irrevocable. It's a Medicaid irrevocable trust, and it allows for the assets to be protected after 5 years. One other thing to point out is the step up in basis that happens. So if someone dies owning property, their cost basis in the property, so what the cost basis is what they purchased it for, gets stepped up to the value as of their date of death. So if you purchase a house for 100,000, at the time of your death, it's worth 400. Your beneficiaries are going to inherit it with a cost basis of 400. If they turn around and sell it, that's going to minimize capital gains. With the trust, you still maintain that step up. The property will still get a step up in basis when it passes to your intended beneficiaries. So that's an important thing to note. Okay, so we've talked now about making sure your estate planning documents are in place, considering asset protection from a proactive standpoint. Ideally, when you're in a place where although we don't know what's going to happen, there's a good chance you're going to make it through 5 years. So now we move to more of a crisis planning situation where Medicaid financial eligibility when care is needed. So when we're talking about how does someone qualify for Medicaid, so they need long-term care, they're burning through their assets, how does someone qualify? And the factors that are used to determine financial eligibility, are looking at someone's assets, their income, and as I mentioned, whether or not they've transferred assets, resulting in a penalty period. So, as I mentioned, the applicant for Title 19 or Medicaid can only have $1,600 in assets. If they're staying at home, so if they've applied for the Connecticut Home Care Program, then they can keep a certain amount of income. They can keep $2,700 in income. If your monthly income is over that, there are things that can be done. You can put your excess income into what's called a pooled trust. Pooled trust, which is administered by Plan of Connecticut, which is a nonprofit organization. When you do that, they develop a spending plan so that if any living expenses need to get paid out of the trust, they can be paid on a monthly basis. What happens is any remaining assets in the pooled trust, when you pass away, are gone. They go back to Plan of Connecticut. So those assets are, while they can be used, the trust can get you eligible for Medicaid. Anything remaining will not pass to beneficiaries. Okay, so what if you didn't plan? So you didn't do the proactive planning, and someone gets sick or gets a diagnosis. we're going to talk about that now. So what we call crisis planning. And here you see just a quick slide here that Connecticut is trending home. In 2001, 201 licensed nursing facilities were operational in Connecticut in 2002, and the numbers going down. More people are choosing to stay home, um, and nursing homes are being consolidated. So the landscape's changing here. So if you want to remain at home, as I mentioned, there is a funding mechanism that's through the Connecticut Home Care Program for elders for people who are 65 years of older or older, Connecticut residents, must be at risk of nursing home placement. So they must need assistance with daily living skills, activities of daily living, such as bathing, dressing, eating, medications, toileting, transferring, all of those types of things. So, and they must meet the financial and functional criteria, eligibility criteria. So they're underneath the Connecticut Home Care Program. There is both a state-funded program and a Medicaid-funded program. The state-funded options provide more limited care. They do have a higher asset limit, and they also involve a copay. So they'll provide the care, but there is a copay that you must pay on a monthly basis for the care. Whereas with Medicaid, it's paid fully. So some of the, if you qualified for the Connecticut Home Care Program, some of the services include care management, adult day health services, companion services, home delivered meals, homemaker services. And for more information, I would strongly encourage you to go to the state website that I have here, and also to the Agency on Aging. Agency on Aging are access agencies. They're nonprofits. They are situated. There are multiple agencies situated throughout the state of Connecticut. They're funded by federal and state dollars, and they offer a wide variety of resources to people who need care and also to caregivers. So there's respite services that can be available. They do provide assistance with applying for state-funded Medicaid. They provide assistance with Medicare issues. They are a wealth of information as far as what programs are available for people. So strong recommendation for that to look into that. So in addition, we like to talk about, looking at a holistic approach. So many times when someone is just wants to live at home and perhaps the family is trying to make that happen, and there's uncertainty about what is needed for someone to be able to stay at home safely. There are what we call geriatric care managers who are available to assess the home, assess the individual, make recommendations about what adjustments or need to be made in the home so that someone can stay there and live there safely. This can be helpful in a situation where there's a disagreement among people about what the person actually needs. This is because this is an independent third party who was making this assessment and recommendations. Making a plan for transportation, seeing what other options are available in the event that you can no longer drive. There could be the senior centers provide transportation at times. There's, Uber, just looking to see what's available in your area. Making your health a priority, so keeping yourself in good shape, eating a balanced diet, making a plan for potential care in the future. So in the event that you need help, who will be available to do that? Will that be a child? Will that be a family member? Will you be paying privately? And that's also sometimes important because if you have a child, perhaps even a child who lives with you, and the plan is for them to give you care, there are ways to transfer assets to child caregivers. There's rules that apply. but they will not be considered a gift for the purposes of applying for Medicaid. So that is something that, again, there's specific rules that have to be followed. In some instances, there needs to be a caregiver agreement in place with that person who's providing the care in order for the state, in order for you to compensate that individual. Okay. So wanted to run through, still no questions. I don't see any questions here. Wanted to run through some scenarios for you. For someone who is, for different scenarios where someone needs long-term care. So in the first one, we have a single person. And this is saying the person needs care. They, when you want to live at home and you apply for Medicaid or the home care program, you can continue as long as you're living in your house or someone else is living, your spouse is living in your house. The house is not considered for the purposes of assessing your financial eligibility. So your whether or not the $1,600 limit that you can have, the house is not looked at. So you can still qualify, keep your house. The tricky thing can be, being otherwise eligible under $1,600 and still maintaining enough money through your income to pay the costs of living at home. So not the home care costs, but just the cost of upkeep. But let's say that happens and you're able to get home care funded, then you can keep the house, but upon your death, and the state will attempt to recover what it's paid on your behalf. When it was paid on your behalf. So they're going to file a claim against your estate. So if the house is now part of the estate, it gets sold, the estate's going to look to be paid back what it paid for your care. If you're living at home and you're on Medicaid, the home care program, and you transfer to a nursing home, you're not longer able to stay at home, then the nursing home is going to expect that you sell the house and use the funds to pay for your care. The house will no longer be exempt because you're not living in it, unless you have a spouse, but here we're talking again about a single person. Okay, so the second scenario is we have here a married couple. And they're biking together. Looks like the husband's a little bit of a daredevil, and there's a bike accident, and the husband is injured. The wife walks away fine. So in this scenario, the husband and wife have $150,000 in assets plus a house. The wife, she survived the accident, is still fine, healthy, living at home. Can they apply for Medicaid to pay for the husband's care? Under the laws of or the rules for Medicaid for married couples, the wife can keep the house. She's still living in it, and she can keep some of their share of the rest of their assets. The husband can apply for Medicaid. So let's see how that works. Okay. So the wife, the rules of Medicaid allow the community spouse, the healthy spouse, to keep a certain amount of money. So we know that the ill spouse can only have $1,600 in assets. The healthy spouse can keep, you take the total combined assets of the married couple, divide it in half, and the healthy spouse can keep a maximum of $162,660, a minimum of $50,000. So the other assets that are exempt are the home, the one car, so that's not counted, and her income. If the husband is living at home, wants to continue living at home, he keeps his income. However, if it's above the amount, the $2,700, then he must then put the excess income into a pool trust, as I mentioned. And as long as they are under these requirements or they meet these requirements, he would qualify, and the spouse can keep a portion of the assets. You've probably heard about spending down. So spending down means using your money to spend down to get to a level where you financially are eligible for Medicaid. These are some of the things that we recommend are purchasing an irrevocable prepaid funeral contract. You do that through a funeral home. Perhaps if you need to renovate the house to make it accessible and safe for someone to continue living there. If you have certain things that are not covered by insurance, if there's dental work, hearing aids, those types of things, those are also good things to use the money for. And sometimes people may want to, because the car is exempt, may want to upgrade their car. So I get questions from people who are very concerned about spending money and say, well, is it okay to buy this, or is it okay to buy that? Purchasing something for fair market value is not considered a gift. So the state's not going to critique or analyze purchases as long as they are for fair market value. So I mean, you're still entitled to spend your money, in other words. Okay. So a couple of things just to point out is that um, married couples, spouses can transfer assets back and forth. That's not considered a gift. It is a gift if you give money to your children or assets to your children or someone else, but spouses, that does not apply to. Okay. So, because we're talking now about the 5-year look back and whether or not you've made transfers of assets. Other exempt transfers. So, if you need to get on Medicaid and um, you have a disabled child, so a child perhaps it's receiving Social Security disability, receiving Medicaid, you can transfer assets to the child, and it is not considered a gift. Also, the caregiver child. So if your child has lived with you for 2 years prior to applying for Medicaid, and they have provided care to the degree that without that care, you would have needed to be in a nursing home. So it's a commitment. And the state looks at this closely. They would want documented evidence of your level of need. And they will look closely at, if a child has a full-time job and then claims to be caring for their parent to that level, the state's probably not going to accept that because there's no way that you can do both. But for some people, their child lives with them and cooks for them and cleans and takes them to doctor's appointments and perhaps helps bathe them, helps dress them. And in that case, they are eligible to perhaps receive the home or other compensation for the care that they've provided. So we're going to talk about purchasing and annuities. This is one asset protection strategy that sometimes we use. It's very effective with married couples. And this is something we would do in a crisis situation. So this is a situation where someone needs long-term care. They're looking at a very large bill, healthcare costs, long-term care costs. And many times there's a concern about making sure there's enough money for the healthy spouse to live out his or her life. So I want to just explain to you a little bit about how this works. There's a special kind of an annuity called the Medicaid compliant annuity. And the way that it works is I've told you that a healthy spouse can keep up to $160,000. But what if the married couple has more than that? So the options are that they can spend down to the 160,000 until they're financially eligible, or we sometimes use this strategy where we convert excess assets greater than the 160,000 into an income stream for the healthy spouse. This is a strategy that it's complicated. It has to be implemented and executed very specifically in order for it to work. And its timing is also really important. It's done in conjunction with a Medicaid application. It's a special kind of annuity that must be non-assignable, irrevocable, actuarially sound. It must be set up so that it pays out to the healthy spouse within their life expectancy. And also, the state must be the remainder beneficiary. So, what that means is that if the annuity is set up and it's paying out to the healthy spouse and the healthy spouse dies, the state has to be the primary beneficiary on that annuity. So, in that way, the state attempts to get paid back for what it's paid. So, I'm going to show you, explain an example of how this works. So, here we have a married couple. They own a house and a car, and they have $500,000 in liquid assets. The husband is ill, needs long-term care, and he needs to go on Medicaid. So the wife, as the spouse in the community, is entitled to keep the house because the house is exempt, the car, because one car is also exempt, and $162,660 in assets. So as long as the husband's is at 1,600 and she can keep 162,660. So the wife she keeps the 162. She still has 337,000 left in assets. So she's over the amount she's allowed to keep. So she decides that she's going to do the home improvements that she's been putting off, purchases prepaid funeral contracts, does some dental work. Now she's down to 300,000. So she's $300,000 left in assets. So the wife purchases an annuity for based on her life expectancy, which is usually 5 years. So she's receiving now an income stream of $5,000 per month. So she's taking her excess assets and she's converting them into an income stream. Husband is financially eligible. He has he's under 1,600 because we've transferred everything over to the spouse, to the wife. And now they are financially eligible. After he becomes eligible for Medicaid, she saves back up the money that she's getting through the annuity. And that's okay, because what matters is that in the month of application, they are under the financial eligibility limits. So here's a scenario where you have a husband and wife who did plan proactively. They set up a trust and they funded it. So they're outside of the 5-year look back. House is protected. Excuse me. Again, they have 500,000 in liquid assets, and their home's worth 400,000. The home that's in the trust. So again, husband needs to go on Medicaid. Wife is in the community. She's entitled to keep a house. Mind you, the house is in the trust, but she's entitled to keep a house and a car and $162,660 in assets. Ignore that 154 at the bottom of the slide there because that's the old number. So one of the ways that the wife can spend down is that she can purchase the house back from the trust. She purchases the house for 400,000. Now the trust has 400,000 in cash from the home sale, and she owns the house. And again, the house is exempt because she's living in it. So now she's got $100,000 of liquid assets, which she's under her Medicaid max of 162,660. She has the house, but that's okay because it's exempt. And now they are both eligible, financially eligible. They meet the financial eligibility requirements for Medicaid. Husband gets on Medicaid, and after that point, the trust buys back the house for 400,000. The house is back in the trust, and the wife has the 400,000, and the husband is on Medicaid. So that's another situation where they're taking advantage of both proactive and crisis planning strategies to protect assets. So there's some examples. I know I'm throwing a lot of information at you, but the point is that if for someone who has not done proactive planning, particularly for married couples, there are strategies that can be used to protect assets, particularly so that the healthy spouse can continue living in the community, throughout the rest of their lifetime. And this can be especially important if the healthy spouse their income is limited. Um, we don't typically do annuities for single people. We do sometimes. They're a little bit trickier. And that's really something we discuss on a case-by-case basis with a client. I don't see any questions in the chat. I'm not sure if the chat's not working. If you want to ask me questions, you can feel free to come off of mute, because I'm not sure here
Thank you,
if the
Erin, for
chat's working.
thank you so
Okay.
much